You're tuned in to Agriculture Today, and we start our Wednesday show discussing some things farmers don't think about but probably should with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Well, thanks for having me.
Roger, talking through a few different topics today, and first discussing water right abandonment and what is sometimes a concept that gets overlooked.
Well, I think, Shelby, the overlooked concept here, and every state's water law is a little bit different and it's nuanced. So I may talk about kind of Colorado and Nebraska and Kansas real quick. But in this area of the country, water is a legal property right that you can actually lose through non-use for a specific period of time. So farmers, particularly in Colorado and Kansas, are subject to the use it or lose it doctrine. So if you stop using a portion of your water right, maybe due to a shift in crop rotation or conservation efforts, then the state might determine that right has been abandoned. And that's what you want to be afraid of.
Are there ways they can save themselves from not having it looked abandoned or, per se, losing it?
Yeah, and I think what farmers need to know here that they often overlook is that I think the most immediate difference between the states is how long you can leave your water untouched before the state starts asking you questions. And in Kansas, that's 5 years. So if you have 5 successive years of non-use or 10 in Colorado, then in Kansas, you're going to trigger an automatic deemed abandonment by the state. Now in Colorado, a little bit different. It's just a rebuttable presumption that you've abandoned your water right. Now in Kansas, the burden of proof, once they deem abandonment because you didn't use your water right or a part of it for 5 years in a row, the state's going to have to show non-use. And you have to show due and sufficient cause for your non-use. So maybe the reason is that you've got better irrigation equipment, more efficient irrigation equipment, don't need to use as much water, don't need to use water because it rained a lot, for example, for a number of years in a row. And so you can push back on the state with respect to their claim that you're not using your water right. Now in Colorado, the state's going to put you on an abandonment list and you have to prove that you intended to keep the right. So a little bit different there, but you need to be aware of what could happen to you if you don't use that water right for a long enough period of time.
Do you see producers often having an issue with this?
Oh, it happens. Yeah. This will primarily come to me through the Kansas Ag Mediation Service here at K-State. And we just have to go back through the records. So what have been your water use records? What was the reason why you weren't using as much water? Just to show the state that you had conservation efforts in mind, that you were not abandoning your right. You had a good reason not to use that right. And the same thing would apply if you're in Colorado. You can fight to stay off that list by showing that you didn't actually have intent to abandon. So evidence becomes the key. And in Kansas, the rule is if you have due and sufficient cause, the statute says, for not using your water right, you've got to be able to show the state that, and then you can keep your water right.
Roger, any other important thoughts for producers on this?
Yeah, I would add that if your farm's in an area where the aquifer is closed to new appropriations, which is very common in western Kansas, then the law is more lenient there because the state doesn't want to punish you for saving water in a depleted zone.
And something else producers might want to be keeping in mind, this one involving tax and estate issues and looking at stepped up basis. If people are thinking about gifting things maybe to the next generation or whoever might be taking over the farm, what should maybe they consider besides land?
Well, there are a couple of issues with respect to that. One is to don't overlook your basis issue. Again, I think a revisiting of the basic rules here is always beneficial. Basis is the key concept for determining taxable gain, taxable loss, and how you acquire that asset pegs your basis. So if you bought an asset, we're going to start with a purchase price. If you receive the asset by gift, we're going to look at the donor's basis. That's going to carry over into your hands. Or if you're gifting assets to a child, for example, they're going to take your basis in the asset. So that could be pretty low if you've held that asset for quite some time and it's appreciated in value, or you depreciated the asset out. And now you gift that to a child, and maybe there's no basis in that for the child because you wiped out your basis. So understand that. So that's purchase price, that's gift. And of course, the rule is retained with respect to inherited asset, and that is we get a fair market value basis as of date of death. So if I inherit an asset, I'm going to take the value of that asset at the time the individual that died left it to me. What was the value at that time? That's going to be my basis. So that's the key concept we want to start at when we're planning gifts, when we're planning estates, those types of things. And for most people, we want to keep the assets in the estate so that we get a step-up basis. The exclusion is $15 million. That's a green light for us in many situations. It's going to cover the assets in the estate. There's not going to be any federal estate tax. So then we can leave those assets with a step-up basis to the next generation.
If people are wanting to transfer something maybe to that next generation, what is an option for them?
Well, some options with respect to that would be maybe I don't transfer the land. I'd put that in some sort of entity other than a C Corp. So maybe transfer individual assets, maybe transfer high basis assets if I want to do some gifting during life, and the other low basis assets include in the estate so that they get a new basis at death. So just kind of do it on an asset by asset piece by piece, do it on an asset by asset basis. That might be the best way to do that. So look to see what type of assets you have, what is their tax characteristic, and then make the best choice for you and the next generation, considering where you're at on your income tax basis.
And while we're thinking about estate planning and that next generation, often the subject of fair versus equal comes up, and what has continued to be almost an overlooked issue.
Well, one of the overlooked issues here is just leaving all my land in co-equal shares to my children. So if I have multiple children, let's say I have 4 children, I leave my land in co-equal undivided ownership to the kids so they each have an undivided fourth. Well, yeah, that's okay. That sounds fair, and it sounds equal, but it's not really fair. Because you may have 1 or 2 children that want to stay and continue to farm, but the others don't. And so they view that as a dead asset. They want to get their cash out of that. So what you run up against in that situation is the right of a co-owner to have the property partitioned and sold, and then you split the proceeds. Well, that's a problem for the on-farm heir. They have no legal protection from the off-farm siblings if you do that. So usually the suggestion there is to move the land into an LLC with some strict operating agreement and maybe have good buy-sell provisions in there or long-term payouts so that we address that issue. Basically, what you want to think about is getting dollars into the hands of the off-farm heirs and control in the hands of the on-farm heirs. And there are many better ways to do that rather than just simply leaving the land equally to all your children.
On operations also, sometimes there's equipment that's used for the farming operation, but also for a little bit of recreational fun. And is there an issue sometimes that these operations run into?
That's a sales tax issue in many situations. So I've got, say, an ATV that I buy. I use it 60% for farming. Maybe I'm spraying crops. Maybe I'm checking CRP ground, those types of things. I'm hauling tools around. I use it on the farm. I use it basically as a farm vehicle. Well, I use it 60% of the time on my farm and 40% for recreation or hunting, or when the grandkids come and the grandkids get to use that. Well, that may void your sales tax exemption. A lot of farm equipment purchases for use on the farm are not subject to state sales tax, but state auditors are trained and they're increasingly aggressive about checking for personal use on tax-exempt ag purchases. And what I find here, not only is that point overlooked, but what's also overlooked is that farmers rarely keep a log of equipment use. But I think having a simple logbook showing your ag versus personal use for dual purpose vehicles is essential to defend against an audit from the Kansas Department of Revenue. Those 2 points there are overlooked all the time.
Is there a ratio of which it has to be used for farm use versus personal use?
There's nothing hard and fast in the statute, but what you want on that is your primary use to be in direct production of agricultural commodities. And I'll just leave it at that. And so if that's the case, or that's what you want, the better situation would be, in my ATV example, have 2 ATVs. Have one that's used for recreation purpose and one that's used for the farm. Then there's no question. Now, you won't get the sales tax exemption, of course, on the one that's not used for farming purposes, but you're going to escape an audit question on that too.
And while we're talking about machinery and equipment on farming operations, are we seeing sometimes a tax trap when it comes to trading in machinery?
We see a big tax trap, and this gets overlooked all the time. Starting in 2018, the tax-free exchange rules under Section 1031 of the tax code no longer apply to personal property. It only applies to real estate. And so the overlooked issue would be, for example, Shelby, if I trade in a $300,000 tractor for a new one, the IRS is going to treat that as a sale of my old tractor and the purchase of a new one. Well, with bonus depreciation now back to 100%, for assets acquired and placed in service on or after January 20th, 2025, there may be no basis in that old tractor. Or if I took a lot of Section 179 on it, I've wiped out the basis. So that sale triggers depreciation recapture, and that's all taxed at ordinary income. And even if I sell it on the installment basis, that recapture occurs all in year one, and I may not have any payments coming in to offset that increased tax liability. That is a major trap that's out there, often overlooked.
Roger, I appreciate you taking the time to join us today.
Thanks, Shelby. Appreciate it.
That was K-State and Washburn law professor Roger McEowen.